Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appearing on behalf of people. I think counsel is outside.
Can you get, you stay here, that's the court officer's job. Can you get this, please? And then people just sit there and watch. I'm tired of that. Yeah. Just enjoy. You can do that, just enjoy. Parents for the record, please.
Hi, good morning, Your Honor. Dustin Cruz for Dominique Development.
Where is she?
I don't know, Your Honor. I did have contact with her before 8 o'clock this morning, letting her know I would be here at around 8:10, that I was running late. She said, okay. That's the last I heard from her. I sent her another text at 8:22, just checking in. I gave her a call and sent her another text just a couple minutes ago after I saw Your Honor in the hallway. I have not heard back from her. I don't know what's going on. She's appeared every time before this. But I don't.
She's on tether, correct?
She is, Your Honor.
What's your picture?
Would we be able to hold that in abeyance if she's able to turn herself in?
This is the date set the trial. She should have been here. Your witnesses are here?
Yes, the complaint witnesses.
She's literally got 5 minutes to get here before it's too late to call a jury. So I'm going to move forward to the next jury trial. This is Michigan versus Montreal Carrington, 26-00349. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appearing on behalf of people.
Defender Joseph Hardy on behalf of Mr. Carrington.
Is that Ms. Belafont?
Yes, it is, Your Honor.
Belafont, why are you just not getting here?
I had an issue in the restroom.
Excuse me?
I had an issue in the restroom. I had to stop. I was coming from Romulus.
Who's going from Romulus?
Yeah, that's where I live. Then I had to stop at a truck stop.
Okay, why didn't you make contact with your attorney so you knew what's going on?
There was a mistake on my behalf. My cell phone was in family messages.
Okay.
I wasn't getting his calls.
So we are prepared to move forward with the Belafont trial.
Yes, Your Honor.
Correct?
Or no, well, Your Honor, I believe.
Trial? Yeah, this is a jury trial.
I believe we have made agreement. We sent an email to the court yesterday regarding the defendant accepting the state's offer of heinous charge under 7694A. It was my understanding that was going to be accepted today.
She's pleading guilty to domestic violence, no objection to 769.4A.
Yes, Your Honor.
This is the offer that was extended January 6th.
Yes, Your Honor.
It's almost May,
Yes, Your Honor.
and you tied up my jury docket for what reason?
Your Honor, we received new discovery yesterday afternoon. Discovery that changed my calculus on the merits of our case. We were going to be presenting a self-defense claim. This followed a late filed notice of other acts evidence under 27B by the people with even later disclosure of the actual video evidence. But they got it to us before trial. I was ready to move forward with trial. That's what we're going to do. But certainly my calculus on whether my client should accept the deal changed when I reviewed the video evidence for that other acts evidence.
Okay. I gotta go off the record on this so I can see what's going on before 9 o'clock. Are we running Carrington as a trial?
The defendant, I believe, is felt to appear on that.
Is that correct, counsel?
That's correct, Your Honor. I attempted to make contact last week. It appears that Mr. Carrington's phone is now out of service.
No, it's your benchmark for Carrington. Thank you. Do we have paperwork for your client, or do you need to go over her advice of rights?
I need to go over advice for us.
Okay. I'll call the case another time.
I released the officers in the Carrington case.
Yes. Thank you. I'll pull them out.
Yeah, I think it's true.
Yeah, okay. Okay, State of Michigan versus Jaden Bishop, 26-00128. Appearances, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the state of Michigan.
Assistant Public Defender Justin Straub, on behalf of Ms. Jaden Bishop, who is standing to my right.
Okay, this is the final pre-trial that was scheduled for today. And a PA 53 bond violation. My understanding is that the victim is deceased.
That's correct.
How is deceased?
We are prepared to go forward on the PA 53 violation. Today, Your Honor. Officers here and the complaining witness in that case is here. I believe there is a basis for a new assault charges based off the PA 53 violation. I believe based off that the defendant has agreed to plead as charged under HIDA. Based off of that,
To the underlying charge, you mean?
the underlying charge.
Counsel? That's correct, Your Honor. You have any advice and rights? Okay. So you're gonna plead guilty to the assault and battery with no objection to sentencing under HIDA?
No objection from the people, Your Honor.
That's correct, ma'am? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Okay, you can put your hand down. I have an advice and rights and key information sheet. It's stated for today. Is that your signature? Okay, you went over these rights with your attorney. You understand these rights? And are you willing to give these rights up today to plead guilty to assault and battery? Okay, you understand that you have the right to proceed to jury trial, the right to maintain your innocence and be presumed innocent until proven guilty by the prosecutor beyond a reasonable doubt. Okay, you understand your right to see, hear, or question any witness that's called to testify against you. Your right to call witnesses that will testify on your behalf, and your right to present evidence that you believe show a defense to the charge of assault and battery. You also have the right to remain silent and not have silence be used against you. You understand that? We don't threaten you to get you to waive these rights and plead guilty. Any promises being exchanged or offered to you to get you to waive your rights and plead guilty. Are you on probation or on parole? No. You understand that a guilty plea can result in a conviction that you may need to report to your employer? It also could have impact on future travel or immigration status. As to the assault and battery, how do you plead? Is that because you believe that you're guilty of assault and battery?
Guilty.
Is that because you believe you're guilty? Factual basis.
Ms. Bishop, on August 10th of 2025, were you located at 214 South H Street in Greenfield, Michigan, 48912? Yes. And is that in the county of Bingham? Yes. And at that address, did you strike a Craig Lee Dennis Sr.? Yes. And did you do that in self-defense?
He was satisfied.
The court is satisfied with the factual basis. I will accept your plea and find your plea be freely, voluntarily, and intelligently made. And what is your client doing on this bond violation?
Well, Your Honor, our hope was that that would get dismissed.
Why?
With her pleading.
No, she already got an offer. The offer was they weren't going to issue new charges. That's the offer.
Well, my understanding was that they would also
They can't.
recommend to the court.
I understand that they probably was going to recommend that. No.
If it is possible, Your Honor, we would like to explore the option of a no contest plea.
Why?
Um,
I don't think this is how no contest pleas work. Who is the basis? It has to be a lawful basis for a no contest plea. What's the basis?
I don't think we have a lawful basis, Your Honor.
And we have witnesses here ready to proceed. So either you're pleading or we're running a hearing.
She wants to plead not guilty, Your Honor.
Okay. You call your witnesses.
Call Officer Pellegrino.
You can have a seat. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can have a seat. If you can state your first and last name and then spell both.
Armando Pellegrino, Armando Pellegrino, Pellegrino.
You can proceed, counsel.
Thank you, Your Honor.
Officer Pellegrino.
How are you this morning?
Good, how are you?
Good, good. You get breakfast yet?
Have not, no.
Okay, so hopefully we'll be able to get you out of here quickly. I'm gonna ask you some questions about an investigation or a PA 53 violation that you were involved in. Are you currently employed?
I am
Where are you currently employed?
with the City of Lansing Police Department.
And what's your current duties there?
I'm currently assigned to patrol as a canine handler.
And how long have you been in that position?
I've been a police officer for 7 years and a canine handler for roughly 3.5.
And were you in that position on March 10th of this year?
Yes.
And did your tour of duty on March 10th take you to 214 South 8th Street in the city of Lansing?
Yes.
Is that in the city of Lansing County, city of Lansing, County of Ingham, state of Michigan?
Yes.
And on that date, do you recognize somebody in court today that you interacted with on that date?
Yes.
And can you point out that individual and describe an article of clothing?
Oh, that day I went to that address for a domestic assault and I spoke to the victim who's in the back of the courtroom right now.
Is there someone else in court that you saw on that day?
Not on that day.
Oh,
no.
not on that day, okay. So on that day, at that time and at that location, you said, what was the nature of the call?
A domestic assault.
Okay, and did you talk to the caller who reported the domestic assault?
I did, yes.
How long were you there?
Maybe 15, 20 minutes.
And can you describe what you learned as a result of your interaction with the individual that reported domestic assault?
Sure. I responded to the scene, made contact with the caller. She advised that her and her daughter got in a verbal argument and it ended up turning physical when her daughter threw a bottle of bleach at her.
And did you run the daughter? Did you come to identify who the daughter was?
I did.
How did you do that?
She was identified by the victim, being that it is her daughter.
And did you run her information?
I did in lean, yes.
And after you ran the lane information, did you uncover information about this current case or
I
a
did.
case that she was?
I did, yes.
And as a result of your investigation, based off that domestic incident, what did you do then?
I ran the accused in lean and found a PA 53 violation. I then called our third quarter new desk and got the stipulations of the court order. And then on the court order, it says that she cannot commit a crime while released. And then being that she's being the accused of domestic assault, I would violate that court order.
And then after that, then you signed charges for the PA 53 violation.
I submitted charges for a domestic assault and a violation of court order. Yes.
All right, no further questions.
Service information.
Officer Pellegrino, did you at any time on said date have any contact with my client, Jaden Bishop?
Not on the date of the domestic, no.
Okay, so she wasn't actually there. You did not witness her on the scene.
Correct.
You mentioned that the complaining witness indicated to you that something was thrown at her. Did you observe any injuries
To
to the complaining witness?
she pointed to like an area in her ribcage and that she did not lift up her shirt to show injuries. No.
Okay, so you didn't capture any photographs?
I believe I took pictures, but I don't know if her skin is exposed in any photos.
So you did not see my client there. You did not physically yourself observe any injuries.
Correct.
Thank you.
I just have a follow-up question. You said you didn't see alleged suspect at the time at this location? When did you see her?
Yesterday.
Sorry, yesterday,
Yes.
for the first time?
Correct.
Okay. Relative to this incident?
Ish. I was emailed by the prosecutor to go out there and let the victim know that there was court today. And then
Oh,
that's
okay.
when I observed.
Got it.
Her address.
Oh, sounds good. Thank you. Redirect.
No redirect.
Thank you, Officer Pellegrino. You call your next.
People call Naomi Brooks.
If you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony that you're going to give is the truth and the whole truth under the penalty of perjury? Yes, ma'am. You can have a seat. If you could state your first and your last name and then spell both of them.
Naomi Brooks, Noemibrooks.
Thank you, Your Honor. Good morning, Ms. Brooks.
Good morning.
I am going to ask you a couple questions about a call or an interaction that you had with Officer Pellegrino on March 10th. All right. Do you remember that day?
Yep. Yes, I do.
Can you describe to me what you were doing around 8:30 on that day?
I don't recall the exact time, but I don't know what you mean exactly what I was doing. When I made the call,
When you made the call?
I was arguing with my daughter.
Okay. And you said your daughter, is she present in court today?
Yes, she is.
Can you point around and describe what auto quote phone?
She was on a white shirt.
Your Honor, let the record reflect that the witness is identified as defendant.
Any objection? Identification is needed.
And you live in the city of Lansing, right?
Yes.
Is that in Ingham County?
Yes.
State of Michigan?
Yes.
Okay, so you said you were having an argument with her?
Yes.
And at some point during that argument, did your daughter throw a bottle of bleach
It
at
was
you?
a spray bottle.
Spray bottle of bleach? And did she throw that bottle of bleach at you in self-defense?
I don't even think she threw it for any other reason other than we were arguing. We both just lost my husband and her father. So
So she was upset at the time and you guys
we
were
both
arguing,
were, yes.
and then she threw the bleach?
It was in a spray bottle. It wasn't like she threw actual bleach at me.
Just
or
a bottle. And did the bottle hit you?
No, I believe when the officers arrived, it was still laying on the floor by the fridge. It wasn't even near me.
but she threw it in your direction
Probably.
after she was arguing with you and became upset.
Probably.
And then based off of that interaction, you called police.
Yes, I did because I wanted her just to leave so it didn't escalate into something physical.
Okay. And how long after you called police did they arrive at your house?
Oh, I have no idea.
Was it an hour? Was it?
I have no idea.
And by the time police arrived, your daughter wasn't there.
Correct. We had already de-escalated the situation ourselves. She had left. I was home by myself with my other children, and she had already went on about her way.
No further questions, Your Honor.
Prosecutor.
Please state your name, please.
Naomi, that's-
Ms. Brooks, I'm sorry for your loss.
thank you.
I just got a couple questions for you, Craig. On the night in question, what was that argument about? Do you recall?
I don't even
I
remember.
don't remember. Okay. I hate to ask this, but is it because you were drinking that evening?
I could have been, yeah, I just lost my husband.
Absolutely understandable. Could that have potentially had an impact on your memory?
I don't think so. I'm like, I don't think it would have had an impact on my memory. This was a while ago.
Um, Respectfully, I'd like to call your attention to what was reported by the police officer that evening. He did make mention of an injury, of a potential injury, and that you were struck by this bottle. Do you recall where
No, I
that?
don't.
In the report, it does indicate that the bottle hit you in your right side below your rib area.
It might have. I don't recall it as doing so, but it might have.
Do you recall pointing out for the officer the bottle?
I think it was still on the floor in the kitchen. Yeah.
Okay. Do you remember him taking a picture of that bottle? Okay.
Redirect.
No redirect.
Thank you, Mr. Clerk. Any other witnesses?
No, people rest, Your Honor.
Defense witnesses?
Yes, Your Honor, we would like to call Ms. Jane Brooks to the stand.
You right now. Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury. You can have a seat.
I'm also sorry for your loss. I just have a couple questions for you. On the night in question, did you engage in an argument with your mom? Do you recall what that argument was about? Were you drinking that evening? Do you recall throwing something at your mom? Do you recall being questioned by police that evening?
No.
Okay. Were there any witnesses?
No.
You're not done yet. Thank you.
Yes, I just have a few questions. So this happened on March. And if I give you a question that you don't understand, just let me know. If you answer it, I'll just take it as if you understood what the question was, okay? So this incident with your mom happened on March 10th, right? At like 8 o'clock at night.
I'd say about the time.
And you said you heard your mom's testimony, right?
Yes,
And your mom said that you guys were arguing
yes,
and that you became angry during this argument,
yes.
right? And you picked up a bottle of bleach. Yes,
I guess.
you guessed or you did?
Yes.
You did. You picked up a bottle of bleach after you were angry,
Okay,
right?
right?
No, you have to say,
Yes.
for the record, you have to say yes.
Yes,
You picked up a bottle of bleach
yes.
and you threw it at your mom.
No,
Did you hear her say did you hear her say that you threw the bottle of bleach at her?
yes, I threw it in her direction,
You threw it.
in her direction,
Uh-huh. You
but
threw
it was an empty bottle.
I didn't ask you if it was empty.
That-
I just asked you,
that's-
did you pick up a bottle of bleach?
I picked up a bottle.
Hold on.
Yeah.
Just respond to yes or no to the question I asked, okay?
Okay.
Did you pick up a bottle of bleach on March 10th, 2026, when you were arguing with your mom? Yes or no?
Yes,
After you became angry,
yes,
threw it in her direction
yes,
because you were angry
yes,
over and arguing with her,
yes,
and you hit her
yes,
with the bleach.
yes,
And you knew at that time that you were out on bond.
yes.
And that bond said you
No.
cannot, what?
Responsive behavior.
Just gonna answer the question I asked, right?
Right.
So you were out on bond.
Yes,
You knew that you weren't supposed to commit other crimes when you were out on bond.
yes,
Then you started arguing with your mom and you hit her with a bottle of bleach.
yes.
No further questions.
Anything else?
No, Your Honor.
Thank you, Ms. Bishop. I don't know if that proceeding to argument is necessary. Your client's already admitted on the stand that she threw the bottle at her mother while they were arguing. I don't care if there was a bond for an assaultive action, by the way, that gave a condition that you're not to engage in assaultive or threatening behavior. That is not the basis upon which this is problematic. The basis upon which this is problematic is that you believe it's okay for you to first be arguing with your mom. I didn't grow up in that kind of a household. It might be a cultural thing. We didn't get to argue with our mothers. It's called deference. Even if we disagreed, you can respectfully state a disagreement, but arguing with your mother is crazy work. That's first. Then for you to pick up anything and throw it in her direction or throw it in her house is even more outlandish. And so there's no reason for argument. There's no reason for you to go back and forth about whether or not there's definitely a violation of your bond condition and definitely basis for them to even charge you with another assaultive action when you're already on bond at the time for assault and battery on your dad, I believe. So you think it's okay for you to assault your dad. Then after he passes away, while this case is pending, get into an argument with your mother and then assault her. And then the parties think they can come before me and I'm supposed to give you all kinds of concessions. No, you have a behavioral problem. And if you can't control yourself, if you will assault your mother and your father, you'll assault anybody in here because you have no control over yourself. And people who don't have control over themselves, you know where they should be? You know, that's a question. They should be in jail because you're a threat to the public safety if you can't control yourself. You don't think we all get upset? Guess what? I just lost my mother 3 months ago. Do you think I can go around assaulting people or throwing bleach bottles or bottles that don't have bleach in people's directions because of it? You don't think I'm upset about it? I am, but I'm an adult. You need to get some control over your emotion. And we're not giving you concessions anymore for it. It's time to grow up. I'm sustaining the violation. I'm also accepting your plea. I find that your plea to be freely, voluntarily, and intelligently made. You'll be sentenced on both the violation and the underlying assault and battery on June 16th at 9 o'clock in the morning. When you leave here today, you're going to go down to meet with probation so that they can get you set up for a pre-sentence interview. They're going to ask some questions and delve into what in the world could possibly be going on with you, emotionally, psychologically, physically, that could make you think that you could put your hands or threaten your parents, so that they can advise the court on how they believe you should be sentenced. I'm going to also order that she appears in person for sentencing. Do you have any questions for the court at this time? Get your notice to appear. The probation department will also advise whether or not you're eligible for sentencing under HYTA. The court will make a determination as to whether or not you'll be granted HYTA at the time of your sentencing. Let's see, what is this? I'm going to remind you that you're still currently on bond. You're not to engage in any assaultive or threatening behavior. Do you understand that? Do you have any questions about your bond conditions? Any additional matters for the rest?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set. Thank you. This is the state of Michigan versus Nicholas De Leon, 26-00634 Pierce Place.
Thank you, Your Honor. May I please report, Assistant Prosecutor Attorney David Smith, hearing on behalf of the people.
No, it's going on. Just keep it in jail. Oh, someone's there now. They're both there. Okay. Today was the date set for final pretrial. This is for domestic violence. How are we proceeding?
At this point, prosecution has made an offer, pleading guilty as charged with consent to 769.4A. paperwork here.
No objection to 769.
Yes.
Thank you.
Thank you.
Okay, you want to plead guilty to domestic violence? Understanding that the people are not objecting to being granted sentencing under 769.4A status. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth, the whole truth under the penalty of perjury? Okay, this is an advice of rights. It tells you about all the rights you got to give up if you want to plead guilty. You understand that? So you're presumed innocent until proven guilty. You would have to waive that right to the presumption of innocence. You understand that? That means you give up your right to have a jury trial, your right to have the prosecutor prove your guilt beyond a reasonable doubt, your right to question or cross-examine and confront in court any witness called to testify against you, and your right to subpoena witnesses that will testify on your behalf. You understand that? Anyone threatening you to get you to give those rights up?
No, ma'am.
Any promises being offered to you, not stated here on the record, to get you to want to waive your rights and plead guilty?
No, ma'am.
Are you on probation or on parole?
No, ma'am.
Anyone, do you also understand that by pleading guilty, it can result in a conviction that you may need to report to your current employer or put it on a future job application? It also could have an impact on where you can travel. You might want to go to Canada for the weekend, and they could deny you entry because of this conviction. You understand that?
Yes, ma'am.
As to domestic violence, how do you plead? Is that because you believe you are guilty?
Yes, ma'am.
Factual basis.
Thank you, Your Honor. Mr. De Leon, on March 6, 2026, were you at 412 Pinewood Street?
Yes, sir.
And is that in the city of Lansing within the county of Ingham
Yes, sir.
in the state of Michigan?
Yes, sir.
And at this time you were with a Katrina Syed.
Yes, sir.
Is it true that you were in a dating relationship?
Yes, sir.
Okay. And on this date, is it true that you choked Miss Syed?
Yes, sir.
Okay. And is it true that this was not self-defense?
Yes, sir.
This included factual basis.
People are saying so.
I'm just, the face is because I don't know why you think I'm giving 769.4A. He's already got an offer. That's assault by strangulation. That's a felony. He's only been charged with a misdemeanor. It was a strangulation? That's what choking is often used as. They say choke, but they mean strangulation. That was the factual basis.
The complaining witness said she didn't actually get choked, she got pushed. So
This is discrepancy. No, you didn't get strangled. I don't believe it.
I didn't.
It's the body language for me.
Why didn't?
You get an attitude with me is not gonna change my mind.
I'm not getting an attitude.
Yes, sir.
From what I recall, I did push her. I put my hands up around her to try to leave the bedroom. I pushed her hard with aggression because I was not able to leave my bedroom. And with that being said, that's where the Markins came in. Once the police officers came into the house, whatever she spoke with the officer, the female officer, that was on them. I 100% believe I did not choke her. I remember not putting my hands around her neck to choke her.
Okay, so you did not strangle. So why did you say you strangled her?
Because I'm trying to talk to my lawyer and go on about this.
Oh, no,
didn't-
I swore
Okay.
you in to tell the truth and the
Okay,
whole
yeah.
truth under penalty of
Okay,
perjury.
And I did not choke her then.
You didn't strangle her.
No, no, ma'am.
Because choke is actually when something's in your throat, like you're swallowing,
I did not.
and it gets stuck. That's when you're actually choking. When you, if you put your hands around someone's neck and restrict their breathing in any way, that's a strangulation. Did you put your hands around her neck?
No, ma'am.
Okay. And why couldn't you leave your room?
We were arguing at the time and I was trying to leave my room. And from what I recall, she wanted to just continue to try to resolve the situation. And we were not able to resolve. So as I was trying to leave the bedroom, I pushed her hands up high because when I tried to move her, I was not able to move her.
Oh, so she was blocking the way for you to leave, is what you're saying?
Yes, ma'am.
And so you pushed her out the way?
Yes, ma'am. I did not
Okay, and you
strangle
shoved
her.
her hard.
Yes, I did
Okay.
not strangle
Any
her.
additional factual basis?
Nothing from the people, Your Honor.
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea if I your plea to be freely, voluntarily, and intelligently made. Never agree to a factual basis if that's not what you did.
I apologize.
Yeah, well, it's for your own protection.
Yes, ma'am.
Let's see. Any objection to immediate sentencing?
No objection being accepted.
No objection.
I'm just waiting for the report, but she can make any statement that she wants the court to consider at this time.
No, she does not.
There you go.
I've been employed 7 years at the end of this month. Yes.
Alopecia.
Thank you, Your Honor. As I mentioned, Mr. Daly is, or as stated, fully employed right now. He recognizes that he made a mistake in judgment, something he knows that he should not have done. He's here just to take responsibility and set the consequences as such. And we would refer to the court's discretion. So,
I believe your client would like to make a statement.
I would. My mother is a victim of domestic violence. She's a survivor. I was raised to not put my hands on women. My son saw my actions that night. I'm not proud of what I did by any means. Listening to you talk about, what you just spoke with a previous person, I understand everything. I understand what I did was incorrect. I don't ever want to be in that situation again. I get emotional just thinking about it. Women are better than that. Men are better than that. I am completely, apologetic for everything that I've done. So I'm letting you know right now, that was a bad decision. It wasn't a mistake. It was a bad decision on my behalf that night. There was other ways I could have resolved it. There was other things that I could have done. I didn't. In the heat of the moment, I did something that I should not have. I resent everything that I did that night. I'm truly apologetic. I come here today to push forward and take responsibility for my own actions. I'm not asking for leniency. I'm just letting you know that I'm here to talk to you and let you know that I am apologetic and everything that I made that night was wrong. When the cops got there, they came in, they spoke with me, they spoke with her. She was taken into the bedroom with a female officer. They spoke. Then they came out. The officer that was speaking to me said that Nicholas had already talked to me. He had already said everything to me. He's been really open about it. I freely went. I did everything I was supposed to do that evening, Your Honor. I'm not here to run. I'm here to just take full responsibility for my own actions. But again, I will do better.
Thank you. And so you have I'm assuming a child in common with?
No, that is my girlfriend.
Oh, okay.
I
So
have-
you say your son,
I have 2 children with the mother of my children. Yes, my son lives with me full time. So does my daughter. She's actually due next month. And yeah, I'm a full time father to them. They both live with me. I think
what was the relationship between you?
that was my ex-girlfriend. Yes.
Okay, but your children were present with you at the time.
My son was in the house when it happened. He was in his bedroom.
Okay, because
Playing on his
this
tab.
happened at your house, your
This
home,
happened at my residence.
and
Yes,
she was at your home.
yes, ma'am.
Okay, and
I
then
own 4.
your son was there, and then you say you have a daughter on the way.
No, I have a daughter that's due, pregnant. She's due next month.
Oh,
My
older
daughter-
daughter. So
Yeah,
you're gonna be
with
a
my granddaughter,
grandfather,
yes,
is what
yes,
you
ma'am.
mean?
Yes.
Okay, got it,
My daughter, yeah.
got it. Okay,
I bought my house in 2020 during COVID. I paid it off in 2022.
let's go. I was like, here's the file. Oh, no, that's his file. Okay, I'm waiting for your criminal history, so while they get that, you can have a seat, sir. Thank you for making this statement. You can have a seat back there, because I'm gonna call another case. State of Michigan versus Akeem Johnson, 26-0291. We're just waiting for the prosecutor to return. How can I have your appearance on the Akeem Johnson?
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Akeem Johnson, who's standing to my right.
Okay, this matter was a final pretrial for assault and battery. We have complaining witnesses here.
Your Honor, I spoke with the complaining witnesses are not here today. I spoke with the complaining witnesses yesterday. They appeared in court yesterday. They came up to my office yesterday.
The complaining witness?
Yes, the complaining.
You have the name?
witnesses. They are two minor.
Oh, okay, they're
Children.
minors.
Yes.
You don't have to put their names. You can give me their initials.
That is not this case.
Was-
Akeem Johnson?
This is not this case.
Yeah, because I
okay,
yeah, I have
oh.
Akeem Johnson. It says there,
Oh.
I have John Doe victim.
Yeah,
so-
yeah, okay, yeah, this is a different case. So,
Okay.
the complaining witness is not here,
Oh,
but we were gonna run the case based off of the video at the 30th district court with the security officer.
oh, I remember. This was incident that allegedly occurred at
In the lobby of the 30th
lobby.
district court.
This is not the one that, this is not the one where the allegation that says something about today is the day or something like that. That the
this
Lord
one.
has made.
Yes,
Got it. Got it. Oh, so we're gonna have trial.
yeah.
Is that correct? What are we doing?
We are taking the offer, Your Honor.
Disorderly jostling?
Yes, under height.
You said under,
Height.
no objection to Hyder?
Was it on item?
I don't have that written down on mine,
So
but you're saying you're not, are you objecting to Hyder?
I wouldn't, I thought we were gonna run so I spoke with defense counsel. We agreed that we were gonna go for it. They agreed. The defendant is being sentenced on another case out of this court. He has a pre-sentence investigation for that charge. I believe it was charged as an RNO and it was amended down to an attempted RNO. So that is gonna be back before this court next month. We asked that any sentence that was given in this case be ready to concur with the sentence in that.
He's being attempted. It was a fleeing, attempted fleeing is what he's being sentenced on.
Yes,
And this allegedly took place at the circuit court? Yes. Not because he has a circuit court case, though, correct? He doesn't have a circuit court case. Oh.
No, that case got sent back. It became a misdemeanor.
Is that the one? Is that the flee? Got it. I don't know what case. I was confused. Yeah, I don't know what he had. She said that it got sent back. Was that fleeing sent to the circuit court? No. Yeah, I don't know what case was sent back then. Sounds like you all are still negotiating.
no, whatever if he wants Hyder, we'll take Hyder.
I don't know if he's eligible for Hyder, but I couldn't speak to that. You can only not object to Hyder. I have to decide if it's Hyder or not. And I don't have to give it to him.
Well, we would not object to Hyder again, or again, I it was my understanding that we would run the sentence concurrent with the other.
The
charges.
flee, the attempted fleeing. Now, I'm trying to understand what was sent back from the circuit court.
That was not my case, Your Honor, so I don't have all of the ins and outs.
Because it wasn't the fleeing.
No, it was not.
So there's something else.
I'm going to that.
Someone's been busy.
I don't know.
I don't know. I would say that's a good answer.
I thought it was just the two.
It is just.
Yeah, so you said something was sent back from circuit court.
Well, it was negotiated down to a misdemeanor. It was originally a felony charge.
The attempted flee. That's what she's talking about.
Oh, so that it was never, no, I'm asking why he was at the circuit court. You said that case was sent back.
Oh, why he was at the circuit court that day? I don't-
Yeah, that's what I'm talking
Oh, I don't-
about.
Sorry, I misunderstood.
Got it. Okay, sounds good. Because I was just saying, I don't have another case that was sent back. Okay, so he's got a attempted fleeing sentencing coming. And then he wants to plead to disorderly, no objection to HIDA. You want the sentences to run concurrent.
Yes, that's what we're asking.
I already have a advice of rights. It was signed back on the 31st. You remember those rights? It's the 31st of March. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can put your hand down. Okay, you understand that you would have to give up your right to be presumed innocent until proven guilty. You would have to give up your right to see, hear, and confront in court your accuser. You'd have to give up your right to have witnesses called to testify on your behalf. And then you would give up your right to be silent and not have silence be used against you. Anyone threatening you to get you to waive these rights? Any promises being extended to you if you give up these rights? You're not on probation at this time, correct? You're not on parole. You understand that you might need to report this conviction to your employer. And it could have impact on where you can travel outside this country or get immigration status. As to disorderly jostling, how do you plead? Factual basis.
Mr. Johnson, were you on December 9th of 2025 located at 313 West Kalamazoo Street in Lansing, Michigan, 48933? And is that location otherwise known as the 30th Circuit Court? And did you engage in mutual combat in the lobby of the 30th Circuit Court?
Any questions? Mutual combat.
Well, I
That
didn't
was
know
good.
better terminology for disorderly.
Yeah. People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. What day is this other sentence?
It's May 8th, but so you don't want to appease.
He doesn't.
He already started. But they.
All right, so you already would have your PSI, correct?
Yes, ma'am.
Okay, we're gonna have this set for sentencing on May 8th.
They just need to see these eligible.
Yeah, at what time?
It's at
9 o'clock. So the same time as your other sentencing, okay?
10 o'clock.
9. I don't know why I asked all my sentences were at 9. Okay, let's see. You'll, check in with our probation department before you leave here. I really just need the probation department to advise us to assign the status on that one, because he's already got a PSI. Any additional matters for the record?
Nothing from the people, Your Honor.
No?
Nothing from the-
Thank you, you're all set. State of Michigan versus Maddie Lawson, 25-03244.
Thank you, Your Honor. May I please the court assistant prosecuting attorney Dan Smith appearing on behalf of the people?
Assistant Public Defender Jessica Stroud on behalf of Ms. Maddie Watson, who is standing to my right.
Okay, Ms. Lawson had an assault and battery final pre-trial. Did we have complaining witnesses here?
Your Honor, the complaining witnesses I see is present on Zoom.
Is that the Caroline?
Caroline, yes.
Okay. How are we proceeding?
Your Honor, at this time, you are proceeding to jury trial.
Okay, jury trial is scheduled for June 2nd. I think I need a new trial date, because I think I'm just gonna be appointed for June 2nd. I need to get you a new trial date, though. June 30th. June 30th is your trial date at 8 a.m. Do you understand that you'll have to appear in person for that, ma'am? Did you hear me?
Can you unmute yourself?
Is it AmSpa?
I don't think she knows you're talking.
Is AmSpa?
Yes. Yes.
She's just trying to figure out how to unmute it again.
I'm sorry about that. I do understand, Your Honor.
Okay, thank you. Any additional matters for the record today?
Nothing from the people?
Also, we'll get you a notice to appear. Thank you. State of Michigan versus Matthew Macon, 25-00692. Appearances, please.
Thank you, Your Honor. Making support. Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Matthew Makins, who is standing to my right.
Okay, Mr. Macon has an obscene conduct and disorderly person. There was, or obscene conduct, disorderly person. There was a final pretrial scheduled for today. Not really sure what the purpose was for him to consider the offer. I'm assuming, because I don't require witnesses for things for a disorderly.
That's correct, Your Honor.
How are we proceeding?
He is taking it out.
Plead guilty, no objection to.
I've not had a chance to complete an advice price with him this month.
I'll call the case when you're ready. Let's see here. Who's representing Thurman?
I am, Your Honor.
State of Michigan versus Dominique Belafont, 25-03267. And so my understanding is that Ms. Belafont is going to be entering a plea today to be charged with domestic violence.
That's right, Your Honor.
Okay, you have an advice of rights.
Yes, Your Honor.
Let me have you raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury. I'm just not sure what the prosecutor left after I called the case. An advice of rights and free information sheet. You understand the rights here, ma'am? Okay, and you understand that you would have to give up these rights in order to plead guilty to domestic violence. Excuse me? So that means your right to be presumed innocent until proven guilty. You would waive that right. Is that what you want to do? Okay, so you're going to waive that right, which also means you're giving up your right to confront or question in court any witness called to testify against you. You're gonna give up your right to call witnesses to the stand that will testify on your behalf. You're gonna give up your right to present evidence that you believe show a defense to this charge. And the right to remain silent and not have silence be used against you. Anyone threaten you to get you to plead guilty? Any promises being extended or offered to you to make you want to plead guilty? Are you pleading guilty because you believe you are guilty? As to the charge of domestic violence, how do you plead? Tell me what you did to make you guilty of domestic violence.
Your Honor, may I have one?
No,
Okay,
tell me what you
understood.
did to make you guilty of domestic violence.
On my question, I Alonzo,
And who was Alonzo to you, or who was he at that time?
the time he was my partner.
He was your boyfriend at that time? Where were you when this took place?
I was in the hallway.
What was the address?
501 South Avenue.
Was that in Lansing? Ingham County? Okay, and he didn't ask you to push him, did he? Okay. And was that in self-defense? Any additional factual basis?
No, people are satisfied.
No, thank you, Your Honor.
The court is satisfied with the factual basis. I will accept your plea. If I find your plea to be freely, voluntarily, and intelligently made. Because your victim is here, are you looking for immediate sentencing?
Yes.
The objection.
No objection.
I need her criminal history. Did we get the other criminal history yet?
I can't print it out up here. I have it. Tell you what it is,
Tell me what?
what his criminal history is.
No, I need the, what you mean? You can tell
I
me.
gotta
the
go
criminal-
downstairs for the criminal.
Lord Jesus, is Marquita here? Or somebody who can print a criminal history?
Maybe.
Or Sean? Somebody's got to print the criminal history. So you can't read
They
off.
allow
a
me
criminal-
to use this printer.
You can't, yeah, you can't read off a criminal history to me in the middle of work, so I need to, if you can't do it, can we find someone who can? There's gotta be someone else in here. It's, I don't know if Marquita's here. If she can't do it, is Sean here?
He may be downstairs as well.
Magistrate.
Oh, well, then
I'm
you
sure it
can,
is, yeah.
you can go get it.
All right.
And then can you get this one too?
Yeah, I got you.
Yes, because he's gotta go downstairs to get it. Okay, let's see. I don't see Mr. Hardy in here. If you see Mr. Hardy or Ms. Straub, you have him come in the courtroom. There's Ms. Straub, actually. Is Mr. Hardy out there as well? Who's representing Aldridge?
I am.
Okay, what are we doing with that one?
Taking a picture of this.
Uh,
This is Aldridge here.
She was here via Zoom, Your Honor.
Oh, she needs to start her video, that's all. Jane Aldridge? Okay, this is the state of Michigan versus Jane Aldridge, 266-00434, appearance please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Mr. Straub on behalf of Mr. Aldridge, who is here remotely via Zoom.
Okay, this is a dog at large. Has this been resolved?
Yes, Your Honor, defense counsel has provided me, the people, with pictures of a repaired garage door and they provided sufficient pictures, sufficient of the enclosure of Ms. Aldridge's backyard. So at this time, based off of the representation in those pictures, people move to dismiss.
Okay, your case is dismissed, Ms. Aldridge. Thank you.
Thank you.
Dustin Kolosky, I guess is one of the jail. I don't know which post. Okay. State of Michigan versus Dustin Kolosky, 24-03132. Appearance, please.
Thank you, Your Honor, and may it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Joseph Carney, appearing on behalf of Mr. Kowalski.
Mr. Kolosky has a retail fraud. How are we proceeding on this?
There appears to be a global resolution and a case in front of Judge Hellman. Let's pull up that case number here. It's going to be 25-00648-FY. So at this point, we'd like to schedule another pretrial because we believe that this case will be dismissed.
What is his next case, date and 55th?
I'm seeing that there is a date tomorrow at 8:30.
Is he supposed to resolve this tomorrow then? What is tomorrow's date for?
That's an effort case on another
Pre-
case that's
it's
part
a-
of the.
That's a felony, so what is it scheduled for over there?
I believe that's a circuit court arraignment. There's two.
Is that a bind over date or?
Yeah, I believe so. 25-00648-FY. There was a preliminary exam, at least scheduled was for 9:30.
Tomorrow?
Today.
Or today?
Yeah, and then there's a circuit court arraignment and 26-001-958-FH.
I'm not following. You're saying that there's a global resolution in 25-00648-FY.
Yeah, and
What is that scheduled for next?
what I'm seeing in the schedule, it is today at 9:30.
For an exam?
Yeah, for a preliminary exam.
It's 9:54 and he's on Zoom.
Yeah, I see that. This is the
Mr. Kolosky?
Yeah, so I just got out of court and they pled me to one misdemeanor and they dropped all other charges. I go back for sentencing on, I think, the 28th of next month.
Okay, so he pled on the other one and that was supposed to resolve this. We're just waiting for it to catch up to the prosecutor's office. Okay, give me a minute.
Your Honor, I actually just received this morning. Yes, so I actually did just receive from Abigail, Assistant Prosecuting Attorney Abigail Wilson, a knowledge form
For this case.
So, yeah.
Okay,
based off
so this
of,
case will be
her-
dismissed.
her,
This case will be dismissed. You're all set, sir.
Thank you. Have a good day.
Same to you. Ready on. I think we did that one. We did not. Aswana Thurman. Is that person here? Is Thurman here? Who represents Thurman? Where's Ms. Straub?
that's my script.
She got tether these attorneys. I don't know if we got to find them.
Addie, she sent it to you at,
That is Ms. Straub's
She
case,
did?
but I can
Yeah.
cover your
Okay.
honor, and to our knowledge, Mr. Thurman is not.
at 9:16.
I'll issue a bench warrant. Is Thurman present?
No, Your Honor, she's not. Yeah, she's on Zoom, and she should.
Okay, I'll issue a bench warrant on Thurman. And then Macon. You ready? We're ready with your advice and rights? Okay, Mr. Maker, please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you understand the rights listed here? You're willing to give these rights up? Okay, so that means you're gonna give up your right to be presumed innocent until proven guilty, your right to question or cross-examine any witness called to testify against you at trial, the right to call witnesses that will testify on your behalf, and the right to remain silent and not have silence be used against you. Do you understand that? Anyone threatening you to get you to give those rights up? Who's threatening you? Why you say yes? Okay. Any promises being extended to you to get you to plead guilty? Are you on probation or on parole? You understand that by pleading guilty, it can result in the convictions that you may need to report to your current employer, or you may need to put it on a future job application. It also could have impact on where you can travel outside this country. You understand that? As to obscene conduct, disorderly person, how do you plead? Is that because you believe you're guilty? Tell me what you did to make you guilty of obscene conduct, disorderly person. Excuse me? No, we're not talking general. Specifically, what did you do that was obscene? You have to fight with whom?
I don't remember that name.
You don't know the person? This was in public? Where was it located?
Mario's first,
Where's Mario's at?
so, okay.
Is that in Lansing, Ingham County? Ingham County? Any other factual basis?
People are satisfied.
Where is also satisfied with the factual basis, I'll accept your plea if I plea to be freely, voluntarily, and intelligently made. This matter is set for sentencing June 16th at 9. June 16th, 9 a.m. When you leave this courtroom, you're gonna be escorted downstairs to probation so they can get you scheduled for a pre-sentence interview so that they can prepare a report for the court and they'll advise if you're eligible for HYTA, okay? You can appear for your sentencing via Zoom. Do you have any questions at this time? Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing.
Okay, you can just have a seat until the probation department is ready to take you down, okay? It's on a Nokia X100. I mean, so many Nokias, actually. What's your name?
Carol Lizanne.
Thank you. Okay, state of Michigan versus Keith Wimberly, 26-00818 and 00822. Appearance, please.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people?
Assistant Public Defender Justice Straub on behalf of Mr. Keith Wimberly, who is here via Zoom.
Okay, Mr. Wimberly has 2 retail frauds. One's a second, one's a third. How are we proceeding?
Your Honor, I was just able to make contact with Mr. Wimberly this morning. He is currently an inpatient at Cedar Roots. I would like to extend the offer from the people to him and allow him a little bit of time to consider that offer.
What was the offer?
He was offered, I will let Mr. Smith address that.
Your Honor, the offer was to dismiss the retail fraud second, have defendant plead to retail fraud third, an agreement to pay restitution for both the dismissed case and the case that we did to Target and Meyer. Target and Margaret.
So you need a new court date.
Yes, Your Honor.
He's gotta go down to probation. To May 26th at 8:30. May 26th at 8:30. For you, Mr. Wimberly, do you have any questions at this time? Mr. Wimberly, you're muted. You have any questions, sir?
No.
Okay, your attorney will be in contact with you. Any additional matters for the record?
From the people, Your Honor.
All right.
Thank you.
Thank you.
Back on the record in the matter of State of Michigan versus Nicholas De Leon. Okay, I do have his criminal history here. Okay. I'm gonna sentence him to 9 months probation. He needs to get a substance abuse assessment. And then follow all recommendations. Before you get a chance, follow all recommendations of that assessment. I didn't have any statement from Ms. Desai, one way or the other, that she seemed to be very emotional. So I'm going to continue the no contact order at this time between you and Ms. Desai. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess any firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription, and you will be required to submit to random preliminary breath testing and urinalysis testing. And you have to pay the cost for that. You understand that? I will grant 769.4A at this time. Are you employed?
So I'm 7 years at the end of this month.
Will be maintaining your employment
Yes, I will.
while on probation.
Oh, I can hang up. I mean, I can. You gonna call me?
Oh, we can remove Mr. Wimberly. He's done. There is a $30 per month oversight fee. Make sure you're responsible for each month of probation. $75 crime victim rights fee that will be assessed. A $50 state minimum cost that will be assessed. Total fines and costs will be $395 because I'm gonna waive discretionary fines at this time. You'll make monthly payments on that, okay?
Can I pay it in full?
You can pay it in full.
Thank you, ma'am.
We'll check in with our probation department before you leave here today.
Yes, ma'am.
And then you'll be reporting monthly to probation. Do you have any questions at this time?
No, ma'am.
Lastly, I am going to order anger management group.
What?
Anger management group.
Thank you.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Thank you.
Can I ask a question with the anger management? Is that a place like pads, like I call, I make my own appointment and set it all up, or for the probation department recommend something? for me?
Probation will provide you with your options for how you can proceed to participate in anger management group, okay?
Thank you.
You're welcome. You'll be going straight down there right now.
Fifth floor?
To the 5th floor. Okay, stay, just have a seat, because I'm gonna probably send both of her and him and Bella at the same time. Let's see. Back on the record, State of Michigan versus Dominic Belafont. And I did fail to address the PA 53 violation, which was, I think, an allegation that she was driving by the victim's job, I think. She was placed on tether back during that time, during March 3rd. I've not gotten any violations since then. I'll withdraw this one. She has no prior criminal history. Make your allocation.
Thank you, Your Honor. Obviously, on the night in question, Dominique made some bad choices. She assaulted her then boyfriend. I think both would agree it was not a good environment for the two of them, and that's why they've gone their separate ways. But positively speaking for Dominique, she is, as the court knows, she doesn't have any criminal history at 24 years old. She's working on her education. She has been employed this whole time. She volunteers for the deaf and hard of hearing community. That's Courtroom Michigan State. Okay. And then you volunteer for the Little Caesars Arena.
Yeah.
For in service of hard of hearing people. She's got a lot of good things.
I couldn't hear.
She said she's been doing that for 4 years. A lot of good things going for her. She does have a bright future. I think she understands where she went wrong on October 27th and understands how to avoid putting herself in that situation again. I am asking the court to follow the people's recommendation of 7694A status, give her a chance on probation to prove herself. Thank you.
Does your victim want to speak?
I believe he does, Your Honor.
Given her testimony, it seemed like she didn't really take accountability for what she did, because I'm saying she pushed me, more than just that. So,
I think the prosecutor gave you an opportunity to
I
share
didn't
during
hear
that time, so I don't know what happened. You can tell me now.
During that time when she was physical over just me washing my clothes.
So you were washing clothes?
I couldn't get the opportunity to do that because she was being aggressive with me. So during that time when I was trying to, she was going to bleach and she was hitting me in my face and claiming saying I bit her, but she was hitting me in my braces. So that could be so-called biting her because she hit me in my face and my braces. And during that little time out where she went into the living room to calm down, she came back and was charging at me. And was grabbing my hair and hit me. Then she hit me with the hangers. And I was trying to tell her to stop, just stop. It won't hurt me, but I just need her to stop because I try to avoid pressing charges on her altogether, but I couldn't get that across. But then she hit me on my face with the metal hanger and split my lip, so I had to press charges during that time. I need to try to avoid it. Where I try to give her chances to stop, and I tried to leave, but she said that she would stop overall with me signing the second lease. So if I didn't sign the second lease, I wouldn't be in a situation where I would have to be in court and press the charges against her.
She said she would stop if you would sign the second lease.
I put
Is that what you all were fighting over? A lease?
not the lease. No.
Oh, okay.
So I put boundaries in place. If I was to sign the lease again, that there wouldn't be no hitting and stop arguing. So that was, she said she would stop doing that. So I signed the second lease. During those 4 months up until October, it was just chaos throughout that whole 3 months. So.
Thank you for sharing. Thank you for sharing. It's unfortunate. You're both young, it appears. But obviously, you know, our relationships aren't meant to last. And if you're in a situation where you're in a relationship and you can't seem to get along and that your disagreements are rising to the level where you will feel provoked to violence, you need to leave. You don't need to be there. You don't have the right. He's not your son. You don't have the right to put your hands on him for any reason. But you don't have the right to put your hands on anyone unless it's in defense of them assaulting or hurting you. But that's not what I heard here today. I didn't hear that you were in any way being victimized and that you felt threatened and that you needed to protect yourself. It seems like it was a toxic situation. Sounds like you live in Romulus now. Okay. And so you all have separated. It sounds like that was for the better of both of you all's future. And so you are, there was no objection, I believe, to sentencing under 769.4A. What was it, Haida?
769.
769.4A. So I'm going to put you on a term of probation. Again, this is a first conviction for you. I would hope a last conviction for you. I would hope that going through this process has steered you back to the right direction where you don't want to have any engagement. Just judging by what he did say, it sounds like there had been a history of you all fighting and possibly putting hands on each other. It's problematic. Problematic. Not healthy. A relationship and people are gonna have disagreements and arguments in relationships. You get to use your words, not your hands, not hangers or anything else. Bleach bottles, none of the above. Do you get to use when you're upset? As adults, we vocalize our concerns with our words. And so I would caution you to practice that. The sentence is 9 months probation. While on probation, I'm going to continue the no contact order between you and Mr. Thomas. I'm going to order that you participate in the domestic abuse counseling. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use alcohol, marijuana, or any other controlled substance unless you have a valid prescription. You are required to submit to random preliminary breath testing, and you have to pay the cost of that. I'm only going to order that for 90 days. If there's no violation, I'll suspend it. You understand that?
Yes, Your Honor.
You're not to be at any bars or nightclubs while you're on probation. You also need to participate in anger management group and maintain employment, which my understanding is that you are, or at least you were employed back in October. Are you still employed?
Yes, Your Honor.
Okay, where are you employed now?
I work at Amazon.
You all both work at Amazon? You work at Amazon?
I work one.
at
We did. I live in Romulus and I work.
So you work in Romulus or here?
I work in Romulus
Okay.
and I resign from Romulus.
Okay. Is a $75 crime victim rights fee that will be assessed per statute and a $50 state minimum cost that also will be assessed. $30 per month for probation oversight fees will be assessed. So that's a total of $270 for probation. But your total fines and costs is $395. So I'm going to waive discretionary fines and costs. And I am going to grant 769.4A. Any additional matters for the record?
Nothing wrong with people, Your Honor.
Just a point of clarification, Your Honor, I did not hear tether as a condition of probation.
It is not. She can have the tether removed.
Thank you.
State of Michigan versus Jalen Davis, 26-00030. Here, please.
Thank you, Your Honor. May I please support Assistant Prosecutor Attorney Dan Smith here on behalf of the people?
Assistant Public Defender Jessica Straub on behalf of Mr. Jalen Davis, who is here to my right.
Mr. Davis is charged with a domestic violence. My understanding is that people were expecting to run this trial without a victim, correct?
Yes, Your Honor. So there's, I think, yes, that's my understanding.
How we proceed?
At this time, Your Honor, today was scheduled for I think a jury trial. Today was scheduled for
Motion hearing?
a motion hearing. And we emailed the court a couple days ago to determine how the court wanted to proceed. I'm still new in front of the court. I, at this time, don't fully understand how the court would like to the evidence put before it on of this type of hearing. So it's my understanding, I spoke with Attorney Straub about just discussing preliminary matters, figuring out what evidence we need to put before the court in order for you to make a determination on what evidence is admissible and what how we're going to be proceeding to trial. So
well, let me just start. Part of the issue is when the motion is filed, did you all file a judge's copy?
yes.
I don't have a judge's copy. It's part of the problem. And definitely don't have a judge's copy for the response that was filed yesterday.
My response is filed on
It's
Friday.
date stamped for yesterday.
It was filed on Friday, Your Honor.
It was filed on Friday electronically.
Yes.
At what time?
4:59.
It was filed yesterday. 4:59? We close at 5. You file something that electronically at 4:59 on Friday, you filed it on Monday.
Your Honor, I was going based on this court's guidance that I had 2 weeks to respond. I took all 2 weeks.
I get that, but that's not what I'm asking you. It was filed yesterday then, because the court can't receive it until after you file it. If you
Okay.
don't send it until 4:59 and the court's closed, how is it received?
So for future reference, Your Honor, but at what time should I be?
I'm not suggesting that. If I told you you got 2 weeks, you had 2 weeks. I'm just telling you that we didn't receive it until yesterday.
Okay.
Because it was filed Friday evening, which means it cannot be considered received Friday evening.
Would like the record to reflect it was before end of business though.
At 4:59.
Yes, ma'am.
I don't know, because it's like, I don't know what time, if you sent it at 4:59, I don't know what time cyberspace sent it to us.
Okay. Fair.
Because sometimes you are sitting right here and send an email and I don't get it for a couple
Very
minutes. So it was, I don't think if you sent it at 4:59, it was before the close of business. I don't think that counts. That's like me running up to the federal court with a motion as they're closing the door to say I filed it. You think the judge is gonna see it that day?
No, but I do think the court would accept it.
I'm not saying I didn't reject it.
Okay.
What I'm saying is I didn't receive a judge's copy.
Okay.
Did you file a judge's copy?
I don't know what that means.
Yeah, when you file a motion, which we don't actually have electronic filing for criminal here, so I don't know how you file anything criminally, electronically. Our filing is in person. To the clerk's office, and they would have the date stamp it, and then it goes into the file, and then you would accompany one that says judge's copy. That doesn't go in the file, that goes to the judge, so that the judge can have a copy to read. If you just file along with the court, they put it in the file. Ask me when I see a file. Today. That's how I saw you file the response, because I just flipped in here to see, oh, it was stamped for 8 o'clock in the morning yesterday. Of which no one brought it to my attention. So nonetheless, I'm still gonna handle it today. You just gotta give me an opportunity to read it.
Absolutely, Your Honor.
And then as it relates to how you want to lay out your, you just make your argument. Is that what your question was?
Yeah, Your Honor, I think there's a couple different arguments that I need to respond to defense counsel to see.
You mean you want to respond to their motion or their response?
Yes.
Wait a minute
to their
here.
response.
This is a concern. Let's see here. Is that the one that has the wrong name on it? No. There's just two copies of the defense reply in here. I don't see the prosecutor's motion at all. Defense reply to prosecution's motion, defense reply to prosecution's motion. This one has a date stamp, this one doesn't. So where's the prosecutor's motion? I know, I believe I have it in there.
I submitted on October 10th. You should have it.
October 10th.
So
That's what I'm saying. April?
April 10th. Losing my mind.
You can have a seat, Mr. Davis. This has to be corrected and then we'll get this taken care of. I do not. Oh.
Your Honor, when you say you can have a seat, do you mean in the
You can have a seat back there. I think you were supposed to go to probation, correct?
I was waiting for the court officer to hand us some papers.
I sent it to you already.
You did, but.
Yeah, you were,
I'll take it down.
yeah, you and Bellefonte were both supposed to go on down to.
Yes, I was waiting.
Yep.
Sorry, man.
Okay, I need, this probably was supposed to be my judge's copy because it's not stamped. This one is stamped and put this back in the file. But I need a judge's copy of the prosecutors. And then one should be stamped, should have been stamped and put in the file for the prosecutors on that one. I'll put this back in here. So what is going on here? And then, give me that back, I'll do that. And then who's on, that's Mr. Springer. I have Peterson Havens. Okay, State of Michigan versus Peterson Havens, Sage Peterson Havens, that is 23-03627, appearance, please.
Your Honor, thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Yes, Attorney Marcus Felder on behalf of Mr. Havens, who's approaching right now, standing to my right.
Mr. Havens has a domestic violence pretrial today. We'll see an offer extended.
Yes, Your Honor, may I reapproach?
Yes.
Yes. This is an old case with 23. I told Mr. Defense Counsel.
Sure. Mhm. As the one exhibit? Is that an exhibit? Let me ask. Mr. Smith, on the Davis, I think when you submitted it, you did submit some other attachments. Were those exhibits?
Yes.
Okay, yeah. Okay, you can stand up. Your right hand. You can have a seat. You just come in front of me. Do you solemnly swear or affirm the information or the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Okay, I have an advice, right? You can put your hand down. And plea information sheet, it does have today's date on it. That's your signature, correct? And you went over those rights with your attorney. You understand all of those rights? And you're willing to give those rights away in order to plead guilty to the amended count of disorderly person jostling?
Yes, Your Honor.
So you understand that you have the presumption of innocence until proven guilty. You can maintain your innocence, proceed to a jury trial, require the prosecutor to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and they can't use it against you. You have the right to see, hear, and question in court any witness called to testify against you, and the right to subpoena witnesses that will testify on your behalf and present evidence that you believe show a defense to this charge. And you want to give all of those rights away. Anyone promising you anything to get you to give these rights away? Has there been any threats made to induce you to plead guilty? Okay, and are you on probation or on parole? You understand that by pleading guilty, it may result in a conviction that you might have to report to your current employer, or you may need to put this on a future job application. It also could have impact on where you can travel outside this country or get immigration status. You understand that? As to the amended charge of disorderly jostling, how do you plead? Is that because you believe you are guilty? Factual basis.
Yes, if I could direct your attention to November 1st, 2023. At that time, were you in the city of Lansing, in the state of Michigan?
Yes.
In Amity County? Yep. And on that date, what address were you at?
It would be 2301 South Martin Luther King.
Okay. And on that date, did you get in an argument with Miss Canning?
I did.
Okay. And during that argument, did you place your hands on her shoulders?
Okay.
And did she want you to place your hand on her shoulders at that time? No. And was that defensive?
Oh, for me? No.
Okay. Satisfied.
People are satisfied.
Where is also satisfied with the factual basis on accept your plea, to find if you freely, voluntarily, and intelligently made. We're gonna do immediate sentencing that you can make allocution and then you're a witness can speak if you like.
Absolutely. Your Honor. It's, yeah, my client, up until this point, he'd been residing with Miss Canning. There hasn't been any instances of domestic violence in the interim. I'm interpreting that in a positive light. Now, of course, he's here now, willing to, based on the negotiations and the result in this case, submit to a mental health evaluation, certainly open to potentially going to therapy, et cetera. Going to comply with all the court conditions, and up until now, he's complied with the court conditions of the no contact. And he's gainfully employed with Shaheen. He's really focused on his career right now, things are going well, and his family at the moment wants to be fully compliant with the court and take responsibility and move forward.
Thank you.
So I'm providing this or this statement to offer like context regarding the incident that occurred in 2023. My name is Brianne Canning. I am the fiance of Sage Peterson Havens. At the time of the incident, emotions were heightened, and I do acknowledge that my statements could have overstated the situation. I wish to clarify that I did not intend to pursue criminal charges. Since that time, Mr. Peterson Havens and I have continued our relationship. We became engaged the following year in 2024, and since bought our first home together, and are planning to still carry on that marriage. There hasn't been any similar incidents, and we have both taken meaningful steps to improve our communication and approach with conflict resolution. And I don't have any ongoing concerns regarding his behavior or my safety or my daughter's safety. I do respectfully ask to take this context into consideration. And I do understand that the dismissal is probably not an option, but I ask that in the alternative that the no contact order be lifted so that we can continue our daily lives and share responsibilities. Thank you.
The circumstances that I don't have his criminal history, and in the interest of time, I'm not going to send a probation officer down. He's filling in, so it's up and down for him. Let's see, this agreement was for 6-month probation, and for you to submit to an evaluation and follow any treatment relative to any mental health counseling that may be needed. Sounds appropriate to me. I'm going to adopt that sentencing agreement and sentence you to 6 months probation. During that time, you will undergo an evaluation and follow all treatment recommendations, okay?
Yes, ma'am.
You'll maintain your employment. You won't engage in any assaultive or threatening behavior.
Yes, ma'am.
Due to the age of the case and the fact that you all have seemingly been living peacefully since this time, I will remove the no contact order at this time. And then I won't order any additional oversight other than the mental health component and employment, okay?
Thank you, Your Honor.
And then lastly, there is a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that must be assessed, and $30 per month oversight fee for each month of probation that you would be responsible, okay? So that's $180 plus $125. And you will be able to make monthly payments on that. I'll waive discretionary fines and costs. You're gonna check in with our probation department before you head out today, and then you will report monthly via Zoom, okay? You have any questions at this time? Any additional matters for the
Nothing
record?
from the people, Your Honor.
Thank you so much, Your Honor. Nothing further.
Represents Eugene, I mean, sorry, Corey Eugene Springer, who represents him.
Okay.
each of the three violations.
This is the state of Michigan versus Corey Springer, 25-01621, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Strauss on behalf of Mr. Corey Eugene Springer, who is here remotely.
I must not have referred him to probation. Is that what happened? Okay, all right. He's in custody on a new charge.
That is correct.
I think I probably said it because of a victim, alleged victim. Was there restitution at all on this?
I do believe there was, Your Honor. Yes.
What is the restitution amount?
I believe it was $1,400.
Got it. Okay. You can make allocation.
Your Honor, Mr. Springer understands that he was very much mistaken in his activity on the date in question. He does also understand that he has some pretty serious allegations before another court at this time. He takes full responsibility for his actions in this case. If the court is able at all to refer him for any type of substance abuse treatment, I do believe that that would be well received. Thank you.
If he's being held on another matter, even if he's screened for substance abuse treatment, he can't be released for the treatment. So it's not meaningful because I wouldn't be able to do anything with it if he's screened. He's being held on something. So I'm sure that would be something that he could benefit from, but I can't release him into any treatment at this time. So it's best served for him to get do straight jail, which I'm going to give him credit time served at this point. There's a $75 crime victim rights fee that will be assessed as a $50 statement of cost and $1,400 in restitution that he'll need to repay to the victim. You have any questions about your sentencing, sir?
No, ma'am.
Okay, any additional matters for record,
From the
counsel?
people, Your Honor.
Nothing from the defense. Thank you.
You're all set, thank you.
Thank you.
State of Michigan versus Christopher Alston, 26-00315, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Alston, who is apparently a Zoom.
Okay, this was a weapons reckless use charge. How are we proceeding on this?
This one will be proceeding to trial, Your Honor.
Let me get you a trial date.
June 30th at 8 a.m.
June 30th at 8 a.m. Okay, Mr. Alston,
Okay.
do you have any questions at this time?
No, ma'am.
Okay, any additional matters for the record?
Nothing from the people, Your Honor. No, Your Honor.
We're all set, thank you. State of Michigan versus Jessica Hahn, 26-00351, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Attorneys, I'm not about to look for no more attorneys today. Appearance, please.
Assistant Public Defender Justice Rob on behalf of Ms. Jessica Hahn, who is standing to my right.
Okay, this is a dog license vaccination, which we reset to allow her to be released from custody and address this issue. Has it been addressed?
At this time, Your Honor, it actually has not. The last time that we saw Ms. Hahn, she was in the hospital. She had a longer stay in the hospital than she expected. She was just recently released, so she's not had adequate time to complete those action items. I did confer with the people ahead of time and asked if they would be amenable to an adjournment. So if the court is also amenable, we would ask for that too.
People would defer to the court.
How long is it gonna take you to get this taken care
I'm actually gonna be getting a hold of the Humane Society to see when they do the vaccination and licensing, trying to get a little bit extra help.
I'll give you 30 days, please.
Can do May 26th at 8:30.
May 26th at what time?
8:30.
8:30, okay?
Thank you.
We'll get you a notice to appear. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the bench. Thank you.
Thank you. State of Michigan versus Cario Lizan, 25-01697. Appearance, please.
Thank you, Your Honor. May I please report? Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Okay, and this is your case, sir?
Yes, Your Honor. Public Defender Joseph Hardy on behalf of Mr. Zahn.
Okay, this was an assault and battery, which at the last pretrial, there was no offer. And so we just proceeded to second pretrial for further negotiations. How are we proceeding?
I believe we're going to set this matter for trial.
There is a lay witness in this, would be
Final
requesting.
pretrial?
Yeah.
Final pretrial, May 26th at 8 a.m. Jury trial, June 30th at 8 a.m.
Okay, you must appear in person, Ms. Lizan, on May 26th at 8 a.m. for a final pretrial. And then you have a jury trial June 30th at 8 a.m., okay?
Okay.
You have any questions at this time?
No.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
Okay, you're all set, ma'am. State of Michigan versus Jenica Shireen, 26-00086.
Thank you, Your Honor. May I please, of course, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Assistant Public Defender Joseph Hardy on behalf of Ms. Sharon.
Is she here?
I did not see her in the hallway, did not see her in the courtroom, and when I attempted to make contact, her phone was just.
Is someone supposed to be in post 1, visit room 5? I don't know who that is. Okay, I did reset this as a courtesy because she had attempted to appear back on the 31st and got booted out by Zoom. But she's not appeared today, so it's your bench room. State of Michigan versus Daryl White, 25-02799.
Thank you, Your Honor. May I please report Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Jamie White here on behalf of Daryl White, who's here to take.
He's on tether, correct?
He is, Your Honor.
Okay, today was a date scheduled for a PA 53 and a pretrial on the domestic violence. I think the last stage they was speaking to hiring attorney. So how are we proceeding?
Your Honor, we'd like to set this matter for a trial. And if it makes a difference significantly in the date, we would waive jury and do a bench trial. I kind of checked in with the court officer. Sounded like maybe that's not the case.
Did you want to have a final pretrial?
Well, there's not going to be a plea, so.
Well, that's to see if the victim is gonna appear.
Okay, that would be great.
Final pretrial, May 26th at 8 a.m.
Does that day work for you?
I'll make it
It's
work.
the day after Memorial Day.
I'll make it work. Your Honor.
May 26th, 8 a.m. for final pretrial. Jury trial, June 30th. Okay, and your concern was if it was not going to be, if it was, you were trying to get the day accelerated, is what were you trying to do?
We were trying to get it accelerated.
Okay,
Because he's homeless right now.
because he can't go to, because of the,
No, actually, it's a unique situation. He's not with her anymore for practical purposes. but he's living with his aunt in Elby, and he was, but she saw the tether. She's old school. She was like, "You can't be around my son with this on your leg." So
Okay.
he's part by the GM right
Got it, okay. And that's because of the tether.
now. Right. So I would like to briefly address bond. I wasn't here for the arraignment, but for those reasons. Work together, Judge, 12 hours a day. Court's ready. I just add a little more.
Is he a alleged victim in something?
He is.
Coming from the alleged
So what
fraud
occurred
violation?
is 2025 incident that he's here for today that had occurred. The parties lived together during that period of time, and on the 5th, he was assaulted by her and she was arrested. And the violation has been
I'm not supposed to have contact with her, was the violation.
Yeah, I just want to make sure I get this right. So she was arrested on the 5th, and then the violation was alleged him being in the house when he was assaulted on the 5th. So it's a unique set of facts, but I would say that the violation in and of itself is based on him calling the police on her. And then more importantly, Judge, they work together 12 hours a day. I understand. Of course,
I think I arraigned him and I think it was clear that he worked at General Motors. I think he mentioned that she works at General Motors. I think the issue was the violation is not because he called the police on her. Violation was there's a no contact order. He wasn't supposed to be with her.
Right.
That was the violation.
Right.
He did it to himself.
I understand. So we're asking that the GPS be released off of him so that he can get back in bond. By the fact they work together 12 hours a day already. He just got called back to work, so this is somewhat of a financial strain. I know that's not.
I would imagine sleeping in your car since the 7th probably taught you a lesson. You probably don't want to be around the person the court told you not to be around. Because the next place you can sleep is jail, and then you'll lose your job. And it is not worth it. I'll remove the tether so he can return home to his aunt's house. There's a no contact order between you and Natasha Turner. Which now we have 2 cases, one where you're the alleged victim and one where she's the alleged victim.
I think they dismissed on her after this was issued. That's my understanding.
What do you mean?
I believe
This was first.
Yeah, I believe the incident on the 5th where he was assaulted has been, those charges have been dismissed against Natasha.
I don't even know, were they issued? When were they issued?
That I can't tell you, Judge.
Yeah, that was this month, the 5th. So I don't know. I don't know if they've ever issued anything against it.
I don't know.
Yeah, nonetheless, I'm gonna remind you of the no contact order. You're not to have contact directly or indirectly, nor are you to be within 2,000 feet of where she is. This is not, has no bearing on when you're working, when you're at work. I would imagine and hope that while you're at work, you're actually working and not engaging in activity that will bring you back to court. You can go back and have the GPS tether removed, and we'll see you for your next court date. So with that being said, you want a jury trial though?
Well, yeah, a jury trial with a final pretrial on May 20th.
Okay, so we have the final pretrial and the jury trial was the 30th of June. Okay,
Thank you, Your Honor.
thank you. Ms. Blevins here?
Yes, Your Honor.
He's the one sitting in the dark. Can you stand up and move your body so the light comes back on? You've been sitting in the dark all this time?
Yeah, well, I'm in the room.
You gotta, yeah, it's motion sensor, so you gotta stand up and move your body, sir.
You see me?
At any rate, I brought that transfer paperwork to you yesterday. This case has been transferred to the 30th. I will get a copy of that transfer order. I asked them to send me a copy.
Yeah. I don't know if it's got entered yet. You got it signed by everybody?
It should be on the 30th district website. He entered his plea yesterday at 2 p.m.
Okay, I don't think it's on there yet. At least we didn't see it. Yeah, we don't see it. I don't know that it's gonna be transferred, so we'll set it out so it can be transferred. Mr. Blevins, you're all set.
Okay, I can go then?
You're free to go.
Okay, thank you.
Is Joshua James here? State of Michigan versus Joshua James, 25-01075, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Did I get some of that file by accident? Did I give you that file by accident? Because I don't see his file. No, James. Okay, I don't have his file. Who's his attorney?
It appears that's Ms. Schroeder, not seeing this in the schedule, so I'm really cheap aware of it. I think Ms. Schroeder.
Sure, but we didn't get a report for him when we got there. Yesterday. I need someone from to make an appearance, I guess, on his behalf when we get the file. Thank you. You said we did not get a report?
No, not a updated. It was just competent, not competent. Sometimes it's not.
On the fourth was the last time we got to. That sounds good. Okay, on the record, again, state of Michigan versus Joshua Lee James, 25-01075. Have your appearances, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Jessica Straub, standing in for Ms. Schroeder on behalf of Mr. Joshua Lee James, who is standing to my left.
Okay, I'm not 100% sure why this is scheduled for a forensic review, because we would not need a forensic review 2 weeks after him being ordered to undergo treatment. However, I did yesterday receive a notification from pretrial services with a concern about Mr. James' GPS tether. Are you on tether, sir? Okay. Did you let it die? Is it charged?
It's
One time I had to go get it replaced because there was too much dust. It wasn't working, and I have to do that again. And hopefully I can do it today.
Okay, you need to go do that today, okay?
Yes.
Okay, who told you to come to court today? Was your sister?
No, CMH.
Okay, CMH, okay. I'm glad that you appeared in court. You go get your GPS tether fixed so that you can be safely monitored, okay?
Yes.
And then you still need to comply with your treatment, okay?
Yes.
Okay, you have any questions?
No.
Okay, you're all set for today. Thank you. Okay, this is State of Michigan versus Akira Roper. 26-00910. Appearance.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith here on behalf of people.
Assistant Public Defender Joseph Hardy on behalf of Ms. Roper, who is apparently at Zoom.
Okay, I have a malicious destruction of building and domestic violence. For Ms. Roper, how are we proceeding?
As there are lay witnesses, we would just be requesting a final pretrial.
No offer at this time.
No offer at this time.
May 26th at 8 a.m. for final trial. Jury trial June 30th.
Okay, Ms. Roper, you must appear in person on May 26th at 8 a.m. for a final pretrial. And then you'll have a jury trial June 30th at 8 a.m. also in person at the court, okay?
Okay.
Do you have any questions at this time?
No, ma'am.
Any additional matters, counsel?
Yes, just one thing. This is just regarding the tether that she is currently wearing. I was requested to ask that her should be allowed just an exception just for one single location. That'd be 101 East Jackson, Lansing 4906. That is where her grandmother watches her children on the weekends. She would just like permission to go there to pick the kids up and drop them off.
Is you have any other matters for me?
I don't think-
I don't show another open one from our office now.
No, just because the affidavit of probable cause, which is what was used to charge this, says that she was not supposed to be around him due to there being a PA 53. So there would have had to be another PA 53 other than this.
I don't see anything.
Yeah, I don't. Okay, you want to add an address?
Yeah, 101 East Jackson.
101 East Jackson.
Yeah, and that's Lansing 48906.
And that is within the 2,000 feet, is what you're saying, or within the exclusion zone?
Yeah, she informed me that that's within one of the boxes on the map. She's not allowed to go to.
Okay, I'll have the bond conditions updated to allow that address. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set, ma'am.
Thank you.
You're welcome. State of Michigan versus Brooke Streeter, 26-00448 and 449. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Ms. Streeter, do you have an attorney?
No, I do not.
These were both dog license vaccination matters. Let's see. Looks like she was supposed to. One dog was having puppies. You said April 11th. Have you been able to resolve this, ma'am?
So today, I'm going as soon as we get off this phone to the one on Cedar. I have their both appointments to get them vaccinated, and then I have the $100 to go register them as soon as they're done.
Okay, let me reset this.
May 26th at 8:30.
May 26th at 8:30.
Okay, thank you.
You're welcome. You're all set. State of Michigan versus Jason Walker, 26-00866. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
I should note that while Mr. Walker did apply for the public defender's office, he was denied for not being indigent.
They said you're too rich for a public defender. Might have something to do with the shirt you're wearing. Are you gonna hire an attorney or appeal their decision?
I'm gonna hire an attorney.
Have you been in search of an attorney already, or you need time to do that?
Oh, I was just informed today. I already have another lawyer. Frederick Blackman.
Okay.
Yes, the matter was set for additional pre-trial.
Set this for another pre-trial.
May 26th at 10.
May 26th at 10 a.m., okay?
Okay, thank you.
We'll get your notice to appear. You're all set for today, once you get that notice, okay? You're welcome. State of Michigan versus Alexis Yurden, 25-0346, I'm sorry, 76. Appearance, please.
Your Honor, may it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
May it please the court, Dan Doyle, appearing on behalf of Ms. Yarden, who is appearing via Zoom.
We have a stalking and intentional dissemination of sexually explicit material, 2 counts. So, accurate, 1 count. How are we proceeding?
Yes, at this time, we're requesting a final pretrial, Your Honor.
Yes, we consent to final pre-trial.
No offer at this time.
No offer at this time.
Final for trial, May 26th at 8 a.m. Jury trial, July 7th at 8 a.m.
Okay. May 26th, 8 o'clock in the morning in person at the court is your final pre-trial. And then July 7th is your jury trial, also in person at the court. Okay, ma'am?
Okay, thank you, Your Honor.
Do you have any questions at this time?
I not, if Mr. Doyle could email me those dates, I would appreciate it.
Any additional matters for the record?
Yes, Your Honor, I'll communicate the dates.
Thank you. You're all set. Is anyone else waiting? That's Mr. Davis, correct?
Yes.
You're free to go, ma'am. Okay, I need to go and read this. He's waiting for his notice. This is the state of Michigan versus Jalen Shamar Davis. And then file number 26-00030. Appearance, please.
Thank you, Your Honor. May it please the court, this is the prosecuting attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Assistant Public Defender Justice Rob on behalf of Mr. Jalen Shamar Davis, who is standing to my right.
Okay, the meeting was debates set to address a hearing on a motion filed by the prosecution, which was people's notice of intent to introduce other acts of domestic violence under MCL 768.27B and out of court hearsay statements under MCL 768.27B. The court is in receipt of both motion and brief filed by the people and the responsive brief filed by the defense. Counsel, you can make your argument.
Okay, Your Honor, I think, you know, we may be a little bit premature, make some conclusions, but I wanted to first start off by addressing defense counsel's allegation of Sixth Amendment confrontation clause violation.
Okay.
So first, I believe we have agreed to some extent that the complaining witness in this case does not have to appear automatic and for there to automatically be a confrontation clause violation. I believe based off of my reading of defense counsel's motion, she has conceded that point. So can we start there?
Absolutely.
Well, I think what really matters, right, is whether or not the complaining witness's statements via the 911 phone call, as well as the body worn camera footage, would be considered testimony. And so I think our argument from the defense's standpoint is that they are indeed testimonial due to there not being an ongoing emergency at the time that those statements were made. We refute that there is an ongoing emergency based on the information or statements made by the complaining witness herself. On the 911 phone call, she's very forthcoming about the fact that she initiated physical, forcible contact with Mr. Davis by smacking his phone out of his hand because he was essentially capturing her via a video telephone call. And she felt like that made her look like a bad person. She says this 3 times. She says it twice on the 911 phone call. She also says it during the interrogation by the police once they had physically arrived at her address. And those statements were captured via the body worn camera footage of the officers. So based on the fact that she herself is admitting to the fact that there was not an ongoing emergency, but rather a disagreement that she herself catalyzed, I do believe that those statements should be considered testimony.
Yeah, fine.
Yeah.
So I think again, to address the first issue and not to go over the counsel's point, but the first issue we addressed was whether or not the state, the people had the ability to put on the case absent the complaining witness. So I believe we have both consent that that's not an issue and the people could potentially put on the case absent the complaining witness coming to testify.
I mean, I think that that's clear.
Okay.
Because that's what 768.27C allows.
Right.
So provided that proper foundation obviously is met for the purposes of bringing in that hearsay under that rule of exception. And that, you know, it was made to an officer, that it was made in response to a domestic situation, that there's some reliability, all of that stuff has to be in place. If that's the case, then the precedent is that we can bring in that evidence absent the witness. Hey, why is the witness unavailable?
She just doesn't want to come.
Oh, she doesn't want to participate. Okay.
Yeah.
Okay. So now, as it relates to the confrontation clause, you were making arguments. So
again, to the confrontation clause, again, I don't think that, so to the 911 call, to the confrontation call, to the 911 call. So my position is that the complaining witness in this case was making a 911 call in order to convey an emergency, in order to have the police respond to that emergency. Yet she may have, I mean, I believe the case law is clear on this. She may have, you know, made statements about what happened, you know, that brought police officers to her home on that particular day. But I think the case law is clear that 911 calls are not inherently testimonial. So, I would, so that would be my argument to the 911 call.
Did you want to respond as it relates to 911?
Just to clarify, Your Honor, that is not my understanding of the case law. In fact, my understanding of Michigan versus Bryant is that statements made to a 911 operator while the crime is occurring are non-testimonial, while statements made to an investigating officer after the crime had already occurred were testimonial. So I don't believe that.
I'm sorry.
I don't believe that the case law is blanket restating that 911 phone calls are just per se non-testimonial.
Depends on the condition or the time frame of when that 911 phone call is made, because one of them is made more or less as an excited utterance, like, you know, urgency, whereas the other not so much, like reporting a late crime. Is that your position or your understanding?
Relatively, yes, Your Honor. I think the ongoing emergency part is the most important part of this. The case law also differentiates ongoing emergencies that affect the greater public versus the smaller forum of a couple's dispute. The case law does say that statements are testimonial if they relate to an incident that is actually a private dispute. Again, Michigan versus Bryant.
Did you want to respond, Mr.
Yes.
Smith?
So specifically about the 911 call. So the 911 call was made to dispatch. The dispatch, they dispatched to 911 dispatch, and then they dispatched officers to the complaining witness's address. When the police arrived at the complaining witness's address, they are still looking for the defendant because it's told that it was told to officers that the defendant had a gun. So when they arrived on location, they were responding to the fact that the defendant got into an argument with this complaining witness, that he ran out of the house with a gun. So that was their initial response once they got there. And then when they initially arrived, they did a protective sweep of her house to make sure the defendant was not still in there with the gun. So the officers questioned the complaining witness once they got there about the gun. They made some preliminary findings of whether or not he was going to be taken into custody based off of him having a gun. So the 911 calls were to report that event, and then the subsequent body-worn camera is based off of the allegation the defendant pleading or in the area with a firearm. So I would argue that that's an ongoing emergency.
Any further?
Your Honor, I just would like to clarify. I think we've got two things happening. We've got 911 statements happening, and then we've got body worn camera.
That was clear in their brief.
Well,
Right.
just in terms of our argument, relative to the 911 call, okay, I think that the complaining witness, not just in her own statements where she's identifying herself as the aggressor in this circumstance, but she also demonstrates this through her behavior on that phone call. She's yelling quite consistently at Mr. Davis, asking him to leave. And so, you know, at that point when he does leave, I don't think that it's necessarily fair to, at that point, contest that we've got now a public ongoing emergency when literally that's what the complaining witness is asking for, is that he leaves. Michigan versus Bryan also states that statements are testimonial if they are made in circumstances where a perpetrator is disarmed, surrenders, is apprehended, or as in Davis, flees with little prospect of posing a threat to the public.
But you just said that at the time of the call, she was yelling for him to leave.
Yes, and also using very derogatory terms. She did not appear to be in fear or in danger during
Because
the
she's
call.
using derogatory calls on names while she's calling the police.
Yes, the operator is consistently insistent that she could discontinue her communication with him, but she continues to be aggressive throughout the entire call.
Okay, so this is allegedly the victim is at her home.
Correct.
She's calling 911 and she's excited, she's yelling.
Yes.
And she's actively yelling while on the 911 dispatch for the defendant to leave the home. So you don't think that's ongoing?
An emergency? No, Your Honor.
Actively yelling for, actively yelling.
I'm sorry, why wouldn't that be why? If it'd be different if she called and he had left the home, but he's actually in her home at the time she's calling and screaming.
Yes, and she got to this point, Your Honor, simply because he had engaged in a phone call with his mother and his.
He had allegedly engaged in a phone call with his mother and his aunt about what? Allegedly.
About the disagreement, whatever it was, and it made her feel like she was being highlighted. She says this expressly on the 911 phone call, that it made her feel like she was being highlighted as a bad person, and so she
called the police allegedly because she felt like she was being highlighted as a bad person, or did she feel threatened by him calling his mother and his sister?
I'm not from. So
I don't. You have an attorney. If you'd be in your best interest to let her speak for you. Because I don't even know why you're not being from here. It's nothing to do with what she's arguing. You could be from a whole other continent for all we care. We're on this day in question.
Scared. So
You said what?
you said she's scared.
No, I said I'm asking your attorney a question about, we're trying to identify whether or not this is testimony or non-testimonial evidence. You know the difference?
Yes.
What's the difference?
So a non-testimony is pretty much so a testimony is pretty much somebody just telling their statement, right?
No, that's why you let the attorney do what she's supposed to be doing and don't interject, okay? If you want something for her to consider, you whisper it to her, but you don't blurt out on the record. Because she's the one who studied the law, okay? So she's trying to create a defense for you. Don't disrupt her flow. It's not gonna help you, okay? You can continue.
Your Honor, not all disagreements are emergencies, and I do believe that I don't mean to reduce the complaining witness's statement by any means. I'm sure she felt how she felt. I am just simply highlighting that I don't believe, based on the circumstances of that 911 phone call and the statements that she made, that there was an ongoing emergency, refuting the notion that these statements are non-testimonial in nature.
So you don't believe that if someone is in a domestic relationship and they are in an argument that accelerates for whatever purpose, if they're asking or screaming for someone to leave for whatever reason, that person refuses to leave and they call the police for assistance, that's not an emergency because they were in the middle of a heated argument that could escalate. That's not an emergency.
It's certainly not an emergency to the public.
It's not an emergency unless what? Someone's hit first, or what do you believe triggers it now to become an emergency?
In the case at hand where this incident or where these definitions stem from, there was a person, I do believe in Detroit, who was in the public and had shot a person. In that situation.
Are you talking about the Bryant case?
Yes, Your Honor. Okay. The victim in that case was made statements to the police as the police were actively trying to identify what was happening, what was going on, and they had active fear that ongoing emergency would affect the larger public, not a simple group of people, not a smaller, should I say, group of people. in domestic situations.
Oh, so you believe that if it only affects a smaller group of people, is that your argument?
I'm just going based off of the case law, Your Honor. It does say that domestic violence cases often have a narrower zone of potential victims than cases involving threats to public safety.
So I think the defense counsel has did a good job making a little bit of my argument for me, but and that's no shade to the defense counsel. But so again, what is the larger threat to public safety that was posed in this case? Again, the complaining witness called police after the defendant refused to leave her home after they got into a domestic dispute. That's on the 911 call. That's clear. The complaining witness alleges that the defendant had a gun with him, and that the defendant was in the area of her house with a gun. So when police show up to this ongoing emergency based off their allegations of domestic assault, person with a gun in the area, police show up. Police, we don't know whether or not police would have confronted the defendant, whether or not they would have, based off there being a gun there, whether or not they would have had to use force in the larger community because of his allegations of a gun. But when they got there, they had to do a protective sweep of the home to ensure that he was no longer in there with a gun. So to the extent that this wasn't an ongoing emergency, I believe it's an ongoing emergency from the time that she made the 911 call about the original domestic violence incident until the time that police arrived. They determined that Mr. Davis was no longer in the home with the gun, and they did a protective sweep of the home, and no longer, and that allegation that he was there with a gun no longer posed a threat to the complaining witnesses or to officers that were on scene. So at that point, I would say the ongoing emergency had ended. So we ask that any statements made between the time of the 911 call to the time that police officers concluded their protective sweep of the complaining witnesses apartment, we ask that that all be admitted as non-testimonial hearsay under the ongoing emergency exception.
Okay, any additional arguments? I think I've heard your arguments. I think you both are, we're going where I was going when it relates to the major issue really is the 911 calls, not so much body cam. Nonetheless, the case cited Michigan versus Bryant. I need an opportunity to read that. I recognize you cited it, but I didn't have an opportunity in that short time period to read it. And so I will be doing that prior to issuing my official ruling. However, I am going to be very candid. I disagree with your position on whether or not there was an ongoing emergency. If someone's calling 911 while someone unwanted subject that they're in a domestic violence situation, which we know adds an element there, is in their home and she's yelling, I don't care if it's expletives or not, and she's yelling that she wants this person out of her home, and then allegedly this person has a weapon, there's an ongoing emergency. I don't think that's disputed. That I would agree with the prosecution should extend from the time she's making these statements to the time that the police are there to do their protective sweep to ensure that he has left the premise and that there's no longer an ongoing emergency because he's not hiding outside her house or hiding in a bedroom. We don't know that if that's the allegation. I'm going to read the case law that you've cited. I will make the final determination. I am making it clear there, I think so much on this record where I align. And my inclination is that the prior acts are admissible, both under 27C, but also that there are no violations in this present case as laid out by the prosecution for a confrontation clause. If my reading of Michigan versus Bryant changes that, I'll address that at the next court date, but you'll get my official ruling on the date of the and time of trial, which I believe is got to be rescheduled, correct?
Please, Your Honor.
July 7th at 8 a.m. July 7th at 8 a.m. is the next available date. Was there something else?
Did you already address the prior bad acts? I did think.
I think the prior, Brett, I did address it for the most part. I believe that they're admissible. And so we'll address the 911 confrontation clause issue in more detail at, or I guess on July 7th. As you can see, it's April and we're scheduling now into July, which is why this is why the court takes the position the court takes about playing around with jury trial slots, because it pushes things out unnecessarily. So that's just the next available date, and that could change. It could get bumped, because I don't know, sir, if you have the priority case for that date either. It could be an older case scheduled for that date, and they would have to go before yours, okay? So unfortunately, the case will continue until we can get it resolved. We'll do our best to gauge whether or not this is actually going to run as a trial on the 7th, so that you don't waste time taking off work if this just needs to be reset. But it's difficult to do that when you have situations where people don't show up when they're supposed to show up for trial, or other circumstances could come into play. So, yes, sir.
Yeah, one question, because it's been almost 4 months since I've been tethered, and I haven't made not one violation other than what I want. I mean, other than my charge, I feel like there's really no point for this tether.
You're making a motion to have the tether removed. Is that what you're making?
I'm just asking.
That's what I'm asking. You're making,
Yeah,
you can have the tether. I've not
I
had any
have a
violations.
bruise in my leg.
You can have the tether removed,
Thank you. I appreciate it.
but the no contact order will continue. Any additional matters?
Nothing from the people. Thank you.
Oh,